in my presentation, I wanted to kind of provide a brief overview. I have gone into more detail, of course, in the written paper. The written paper itself was greatly influenced by Professor Chubik's paper because we've received that in advance. So I had the opportunity to take a look at how the Polish system works. So it was a great opportunity for myself also to reflect and compare how much our Central European heritage is noticeable when it comes to recognition matters, and also find some differences. So today it is really a pleasure for me to speak in front of all of you and talk about this topic that I think has a great practical importance, even more so today than ever, because our world is simply more and more interconnected. And, in our civil proceedings, in our notarial practice, we increasingly encounter documents that originate somewhere abroad, from powers of attorney to contracts to birth certificates and different court orders. So it is really important to ensure that these instruments are properly accepted and effective under our domestic law. And I think it's more than just a trivial or bureaucratic matter. It is a complex legal exercise that sits at the crossroads of procedural law, international law, and international cooperation. So today I will outline how the system works in Slovakia, but again, when it comes to more detail, I will invite you to read my paper. I will try to touch on a few differences when it comes to Poland and Hungary, our neighboring countries, but to set the stage, it is worth observing how international mobility and globalization have made foreign documents a daily reality in Slovakia. Since the 1990s, especially after Slovakia joined the EU in 2004, cross-border personal and business contracts have surged in the country. So there are thousands of Slovak citizens living abroad, working abroad, studying abroad, and many foreigners have also settled in Slovakia, resulting in a two-way flow of legal documents. So it is now pretty much a routine practice for a Slovak notary or judge to handle, say, an Austrian marriage certificate or a Hungarian power of attorney. Buying property in Bratislava might involve foreign buyer or a foreign seller even. So an inheritance case might require a court to examine a will or a death certificate issued abroad. So all of these scenarios require that Slovak authorities reconcile the foreign origin of the document and with the domestic legal norms. Now, in other words, what we need to determine is whether the foreign document is authentic and admissible as evidence, and will the legal act that it embodies produce the intended effect under Slovak law. Now, this basic two-step structure for recognition of foreign legal documents applies in Slovakia. So first of all, the first step is the formal authentication of the document. Now, Slovak law draws a very clear distinction between public documents and private documents. A public document, one that is issued by a public authority or officially certified by a public authority, enjoys the presumption of truth as to the facts it certifies. But a foreign public document will only have the same evidentiary value as a domestic public document if it had been duly authenticated, according to Slovak requirements. Now, in practical terms, this means that a foreign official document generally must undergo legalization or an apostille certification. And if a foreign public document lacks the proper legalization, then Slovak authorities essentially consider it unusable. It cannot be treated as a public document and would be ignored or at best treated as a mere private writing with no probative force. Now, unlike some jurisdictions in Europe, Slovak courts have no discretion to waive or cure a missing authentication. So there is no mechanism for a judge to declare an unlegalized foreign document valid by judicial fact. So this is a strict approach that we see in a lot of our neighboring countries as well. and it is kind of intended to prevent fraud and to ensure the formal rigor. Now, this requirement in Slovakia is enshrined in our Slovak Private International Law Act, which is from 1963, and it is Section 52 of the Private International Law Act, which says that foreign public documents have the same probative value as domestic documents only if duly authenticated, unless an international treaty provides otherwise. Now, what counts as a public document for these purposes? Slovak law does not attribute nationality to purely private documents. Private documents can be used as evidence with translation, albeit without any proof or any presumption of authenticity. So the line here can blur sometimes a little bit, because if a document bears an official certification or stamp from a foreign authority, for example, a foreign notary's attestation to signatures, then the Slovak courts would treat it as a foreign public document. Now, when it comes to two parties who privately sign a contract abroad, that can be submitted as a signed contract to in a Slovak proceeding with a translation. But if that agreement is notarized, the signatures are notarized, for example, then it must be legalized or apostilled for it to be accepted as a public document in Slovakia. Now, when it comes to Slovakia, there are two main methods of authentication. First of all, for countries that are parties to the Hague Apostille Convention, the normally lengthy chain of legalizations is replaced by a single apostille certificate. Now, Slovakia joined this convention, signed the convention in 2001 and entered into force in 2002. And the apostille simplifies this process of verification in a sense, because it answers the question whether this document is genuine, but it doesn't answer the question whether the document itself is valid under Slovak law. Now, in everyday practice, of course, the Apostille Convention's impact is limited because a large portion of the documents used in Slovakia fall under a different regime, bilateral treaties or EU regulations. Now, Slovakia benefits from a very rich network of bilateral treaties on legal assistance. Many of them were inherited from the times of Czechoslovakia, which often waive legalization requirements entirely. Now, currently, Slovakia has treaties with a lot of countries. Many of them, of course, are neighboring countries. Now, these agreements generally have been long-standing agreements, especially with our neighboring countries, that abolish the consular legalization of public documents. For example, we have a treaty with the Czech Republic from 1992. And under this treaty, any official document issued by a Czech authority is accepted in Slovakia without any apostille or any legalization, and vice versa. The same applies to our treaties with Poland and Hungary from 1987 and 1989, respectively, among others. Now, this system of bilateral treaties reduces kind of a red tape, because it means that if a Polish notarial deed or a civil registry extract can be presented directly in Slovak proceedings without any further authentication required. Now, the scope of these treaties is very impressive and I think very broad, because they typically cover all public documents. Depends on the treaty, of course. Each treaty is different, but they generally cover a very broad variety of public documents, notarial acts, civil status certificates issued in one contracting state for use in the other. So thanks to such agreements, including not only those with our neighbors, as I mentioned, Hungary, Czechia, or Poland, but also with countries like France, Italy, the Russian Federation, and many others, we have kind of a wide range of foreign documents that can circulate in Slovakia freely without consular hurdles. Now, it is worth mentioning that we have a special case here, and that case is of the Czech Republic, because given the unique historical and cultural and linguistic ties with the Czech Republic, our bilateral agreements go even further than any other bilateral agreement that we have with other neighboring countries, means that in addition to abolishing the need for legalization, Slovakia has formally declared that it accepts documents in Czech language without the need for a translation. Now, of course, this is because of the fact that our languages are very close to one another and there is a mutual intelligibility between the languages. So the Czech is an officially accepted language, meaning Czech language public documents can be presented to Slovak authorities without any translation needed. So I think this language exception is unique in the European Union. And again, it is purely because of the very close historical linguistic ties that we have with the Czech Republic. Now, when it comes to substantive legal effects under Slovak law, once a foreign document has cleared the hurdle of authenticity, it has the requisite apostille or falls under an exception. We come to the second step, and a document, in general, is just a vehicle for a legal act or a legal fact. So a foreign marriage certificate, for example, attests to a marriage. A foreign power of attorney grants authority to an agent. A foreign contract records an agreement. So the question is whether that legal act or status is recognized and can produce effects in Slovakia. Now, this is governed by our Slovak private international law rules or conflict of law rules, as well as, of course, EU regulations and our international agreements that determine the law applicable to the act. Now, in a sense, Slovak courts or Slovak authorities must determine which law governs the content of the instrument and whether under that law and Slovak public policy, the act is valid and effective. Now, a good starting point is the formal validity of legal acts. Now, back to our domestic legislation under Section 4 of the Private International Law Act from 1963, the general rule is that when it comes to the form of a legal act, it is sufficient if the act was carried out in accordance with the law of the place where the act was performed. In other words, the Slovak conflict of law rules follow the locus regit actum principle. So with a certain flexibility or certain exceptions. Now, when it comes to the most important exception, it is the exception of immovable property or real estate. This is essentially a specific category where Slovak law deems them subject to exclusive formalities. So Slovak law, just like many other jurisdictions, is protective of real estate and immovables located on its territory. So, for example, the transfer of real estate in Slovakia is subject to formal requirements under Slovak law. So, and we can see it in many of our bilateral treaties as well. So this is not specific just to our Private International Law Act, but also we can see this as a guiding principle in our bilateral treaties with many countries. So the form of a legal act resulting to immovable property is governed exclusively by the law of the place where the property is situated. Now, this is, for example, the case of the treaty between Slovakia and Poland, where Article 35 says that while in general the form of an act is governed by lex causae, when it comes to the form of a legal act relating to immovable property, that shall be governed by the law of the place where the property is situated. Now, similar wording is found in our treaties with Hungary and many others. Now, another practical thing I think that is very interesting is translation requirements. This is kind of a less glamorous aspect of recognizing foreign documents in the language. Slovak authorities operate in Slovak language, so any document in a foreign language must be generally submitted with an official Slovak translation. This is managed by procedural laws to ensure that judges and officials fully understand the content of the document. Now, typically the translation must be done by a certified court translator. This becomes a bit of a problem sometimes in Slovakia because the certified court translator, as it stands in Slovak law, is a person who is sworn and registered in Slovakia's official list of translators. So the translator attaches a clause and a seal to the translation, and in this way the translation itself becomes an officially translated document. Now, when it comes to the issues when it comes to translation, the fact is that when a party would come with a translation, an official translation, a document that was translated abroad, it still has to be translated in Slovakia by an official court translator, because that is what the law requires, which means that it adds on cost and time to the proceedings, and for rare languages, it can be very challenging to find a translator. Now, there are a few exceptions, as I mentioned, the case of the Czech Republic, where the language is accepted completely without a translation requirement because of the linguistic kinship that we share with Czechia, and this is codified in our law as well. Now, another exception that we have in Slovakia is areas of ethnic minorities. Authorities sometimes show a certain level of pragmatism. For example, when a local registry is in an office or of a town where there is a Hungarian-speaking minority or population above 20%, then the translation is not necessarily needed if the official personally can read and understand the content of the document. Now, I know that we are coming close to the time, so maybe as a few closing thoughts, I would just offer some thoughts on recommendations on where we are and where we should be, or where we will hopefully be in the near future. Now, when it comes to Slovakia, I think one of the challenges is that our Private International Law Act is kind of outdated. It is from 1963. Now, currently, we are in a process of updating our legislation when it comes to the civil code itself. We are in midst of a recodification attempt, and being in these discussions, it is also being discussed what to do with our Private International Law Act, which might follow after the successful recodification of our civil code. Right now, having been in the discussions with the recodification committee, I don't know how successful it will be, this attempt of recodifying our civil acts in general, and how successful will it be to get to a new Private International Law Act. I think we definitely need some integration of significant developments that have happened in EU and international conventions in recent decades, and kind of resolve some ambiguities that can be found in our Private International Law Act. Right now, I think it is a kind of an exciting thought among Slovak scholars and practitioners of private international law, kind of to think even about updating our 1963 Act to meet 21st century standards. Now, I think this is an area that is very exciting because the law here really meets daily practice, and the daily practice is happening in a globalized era. So I think the law needs to keep up with that. Right now in Slovakia, not all of our rules are very flexible. What is positive is a very wide network of bilateral agreements that we have. And I think we have a great opportunity and a delightful challenge in addressing and dissecting these situations and ensuring that our students at the university and our courts understand both the letter of the law and, of course, the practical purpose, how to make life easier in a globalized era for our citizens. So this was a brief overview. Again, I do hope that you find a little bit more time to read the paper, which goes into much more detail. And of course, if you have any questions at the end of the panel, I'll be happy to answer them.